your legal team is already using AI, whether you approved it or not. And if that use isn't contained inside a defined internal policy, every AI interaction is unlocked, unsupervised, and legally undefendable. An internal AI policy isn't paperwork, it's a containment system. So in this video, I'll walk you through 7 building blocks that every AI policy must have if you want AI use inside your firm to be controlled, reviewable, and defensible. I'm Rok, founder of MPL Legal Tech Advisors. We consult law firms and legal teams design and execute AI strategy, turning risk into operational clarity. Most legal teams take one of two approaches. They either ban AI outright, assuming this solves the problem, and it doesn't. It just pushes the usage underground. Or they download a generic policy template, but it never defines which tools are allowed, which data may be entered, who must review the AI-generated output, where usage is logged, or how the violations are handled. The issue here is not AI at all. It's unlocked and unsupervised AI. Law firms got away with massive foundations before, but AI doesn't fix disorder. It scales it 100x. So instead of loose guidelines, you need a containment system built on binary rules. Which tools are permitted and which ones are not, which data may be entered and which is prohibited, which tasks may be AI assisted and which require human-only drafting. And lastly, what must be reviewed and by whom. And this structure separates adoption from exposure. Let's build it properly. Here are the 7 building blocks of an internal AI policy. Building block number 1. Define the scope clearly. An internal AI policy starts with 2 moves: define and discover. Define first what counts as AI use. So which tools fall under the policy? Public LLMs, embedded assistants, office case systems, transcription, summarization add-ons, browser extensions. List them all here. Define what qualifies as AI-assisted drafting versus fully AI-generated content. And define which contexts are covered: internal, client-facing, and personal experiments on firm devices and accounts. The second part, discover where it's already happening. Surface shadow AI, or in other words, unvetted use cases across teams. So public LLMs, plugins, Word, browser extensions, and everything else that you didn't approve. Create a baseline register, which should contain tool, task, and data touched, and mark each entry with a provisional risk tier, low, medium, high, to feed the rules in the next steps. Until scope is defined, and until you surface at least some of the shadow AI use and put it in writing, there is no policy. If a firm-wide discovery feels heavy, that's exactly what our risk and opportunity assessment delivers: fast. So the policy starts from facts and not from scratch. The second building block is steering the risk by the task type. Not every AI interaction carries the same legal consequence. So the policy must separate acceptable experimentation from professional exposure. Here, you're going to assign tiers: green, yellow, and red. Green tier is the low-risk tier. For example, formatting, email tone changes, transcription cleanups, and internal note summaries. Medium risk, so the yellow tier, is drafting internal memos, matter summaries, or intake notes. These are allowed only if the content is anonymized or reviewed before being stored and shared. And the high risk is legal reasoning tasks, privilege analysis, strategy work, or anything that leaves the firm's walls. This is strictly prohibited in consumer and public AI tools, or only permitted inside secure, private environments where data never leaves the firm's control. Once this tiering exists, the team members stop guessing. Every AI task becomes classified, defensible, and accountable, instead of unlocked and legally indefensible. Building block number 3 is approved tools and boundaries set. A policy is useless if it doesn't name which tools are allowed, under what limits, and for which tasks. Approved by class and bind by rules. For example, public models, no client identifiers, PII, or privileged material. Green light tasks only. For enterprise or insulated models, require training opt-out, retention limits, clear data residency, DPA and SCCs, and allow yellow light tasks with review. And then we have private or firm-hosted AI, and that's the highest control. That's the only environment ever to be considered for red zone tasks, if your policy allows it at all. Now, make your boundaries binary inside your register. For each approved tool, record allowed and prohibited tasks, which are mapped to your low, medium, and high tiers. Record permitted inputs, whether a reviewer is needed, storage location, and retention. Default stance should be, if it's not on the register, it shouldn't be used. If it is on the register, the limits travel with the tool. Professional duties stay human, which means AI assists, doesn't replace the independent judgment, competence, or supervision. And any tools used for legal analysis must support source retrieval. Outputs should be independently verified before use. No blind reliance. And then you can define operational guardrails, such as approval workflow, for example, request, and then security or privacy review, and then contractual checks, and then you assign to the owner. After that, you publish the tool in the approved tool register, which should be reapproved annually or quarterly, however you decide. Part of the guardrails is also a feature control. What does that mean? Treat your embedded assistants, such as your MS3X5, as separate tools. Approve and disable per feature, not per suite. Bottom line here is that tool approval is not a logo list. It's a rules-bound register. If a tool's name isn't there, it's out. And if it's there, its task limits and input boundaries are non-negotiable. Building block number 4 is confidentiality and data handling rules. And this is the legal core of the policy. Preserve privilege in use, not by assumption. Number 1 is prohibited inputs. Write them down. Client identifying data, PII, privileged documents, court sealed material, trade secrets. They should never enter the public models. If content must be tested internally, require anonymization or redaction before any AI use. Second, vendor or AI processor safeguards. They should be contractual. This is not just a checkbox. You shouldn't allow training on any of your data. There should be documented retention caps and deletion service level agreement. Next, data residency should be defined. You should have DPAs and SCCs in place. Let's talk about encryption. The data should be encrypted in transit and at rest. And look into the algorithms that they're using for encryption. Just because they use a buzzword, that still doesn't mean that they're using the encryption algorithm that adheres to your professional standards. They must have role-based access controls, and they should have audit logs available on request. Prefer enterprise tenants or private AI with isolation over public endpoint. And define liability ownership in case of a data breach. Retention and storage. Let's talk about that. Set your retention limits for prompts or inputs and the required metadata. Matter ID, author, date. Store AI drafts in a matter file or a segregated folder, never in personal drives or unmanaged apps. Chain of custody. Mark the drafts that are AI assisted, keep the version history, and ensure source retrieval for any cited facts. Clarify that no new AI services or tools may be used without a prior approval from the IT or AI committee, so to prevent shadow AI. And approved tools must carry their usage boundaries and storage rules with them. And align your confidentiality rules with your client disclosure, which will be detailed in building block number 6, including any core disclosure requirements. Bottom line here is that confidentiality isn't a banner headline. It's explicit categories, contracts, retention, location, and logs, all enforceable. Building block number 5. Establish supervision and review requirement. No AI output should leave the firm or reach a client without a human review. Full stop. Set the reviewers by the risk tier. Green is no external use. Optional spot check. Yellow, internal drafts and summaries. Named reviewer required before storage or share. And then red, such as legal reasoning or anything client-facing, partner level review with evidence checks. And define what the review means. Source verification. Quotations, citations, figures, and legal authorities should be checked at source. Reviewer can produce the sources used. No blind reliance here. And labeling. AI-assisted drafts should be marked as such until approved. Define how to record a decision. Reviewer sign-off, name, date, and decision should be captured where your policy keeps AI review record. Because I didn't know is not a defense. A recorded decision is required. And preserve the professional duties. Independent judgment remains with the lawyer. Supervisors are accountable for the work they approve. Competence and supervision standards apply. Remove the ambiguity. Appoint a designated escalation contact, such as an AI policy officer or a partner, for edge cases and incidents, so your team never has to guess. Building block number 6. Decide on your client disclosure and consent posture. Some courts expect disclosure of AI use, and some don't. The mistake is waiting until a dispute to decide. Set your stance now. Start with one binary rule. Do we disclose AI assistance by default or not? And in which scenarios do we make exceptions? Where's the line between harmless admin help and substantive legal drafting? And then we log where disclosure lives. Is it in the engagement letter, a matter-by-matter notice, a court statement only when required? Use one approved wording and not ad hoc emails. Define when consent is required. Which clients or matters are AI prohibited entirely? When must you get a sign-off from a client before using AI for any of their work? And make it provable. Every matter should carry a disclosure flag, yes or no, plus the exact wording used. If you can't produce proof on request, the policy fails in practice. And finally, keep it alive. Review it every 6 months. Assign an owner to track new court rules and ethics opinions. And if disclosure is missed or ignored, the policy must spell out the consequence. Bottom line, disclosure isn't a vibe. It's a pre-decided stance, a standardized language, and evidence you can show when asked. A policy that's not enforced is not protection, it's theater. So make enforcement non-negotiable. Training must be live, not an email attachment. And it must end with a written attestation. I understand the rules and I'm accountable. Define exactly where AI use is logged. Matter file, central register, or both. And what must be recorded. Who used it, for what task, in which tool, who reviewed it, and what decision was made. Then define the breach path. Who gets notified, how fast, and what happens on first, second, and deliberate violations. I didn't know is not a defense. Roll it out small, but real. Pick one workflow, like intake summaries or internal memos, and prove the controls work. You should have full logs in under 2 minutes and reviewer sign-off before anything leaves the firm. When it works once, expand it slowly and safely. Because if you can't produce proof of review or proof of logging when asked, the policy doesn't exist in practice. And once those 7 foundations are in place, AI becomes a controlled assistance and not an open liability. Okay, thanks for sticking till the end. Quick recap. So what are the 7 building blocks that your AI policy needs? Number 1, scope. What counts as AI use? Second, risk tiers. What's green, yellow, red? Third, approved tools and the boundaries around them. Fourth, confidentiality rules. What never goes in. Fifth, review obligations. Who signs off before anything leaves the firm? Sixth, disclosure posture. When clients are told. And seventh, enforcement. Training, attestation, and logs to prove it. That's a real AI policy and not a memo. AI is not the risk. Unsupervised AI is. If you don't know where AI is already being used in your firm, you're already exposed. And if you want this built properly for you, that's exactly what we do at MPL Legal Tech Advisors. Book a consultation. Link is in the description. Thanks for watching and see you in the next one.